Hello, everyone. I am Tammi Caress, founder of Caress Law. We are an estate planning law firm serving both people in Oregon and Washington. And today we're going to talk about a will or a trust. Which one should you have? And now time for the dreaded disclaimer. The information provided in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. Whew. Okay, let's get started. I chose this topic because it is one of the questions that I get when I meet clients for the first time. I have lots of clients that come in and say, my neighbor told me I needed a trust, but they really don't understand what it is. So today I'm hoping to help clarify that for you. We're going to talk about a will and a trust and why, a few of the differences and why you may want to have one over the other or both. So let's get started. I am going to first just talk about a will. Most people know what a will is. It is a document that you create during your lifetime, so long as you have capacity. And it really is laying out who is going to inherit from you and how. It also is going to lay out who is the person or entity that will settle the estate for you. So essentially with a will, you have the creator, and that's always called the testator. And if you want to think about old world terms, there's also testatrix. That is a female will maker. Testator is a male will maker. However, that is very antiquated these days. And now we just call everyone a testator. So that's the will creator. And then you're going to name an executor in the will. Now, I'm using the term executor because most people are familiar with that term. However, in Oregon and Washington, we actually call it the personal representative. And that is the same as the executor. It is the person that you are nominating in your will to settle your estate. And notice that I say nominate. We'll get to that in a little bit. And then the third party or third person or entity that you're going to name is your beneficiaries who will inherit from you at your death. And you get to name that in your will. So it's a legal document. And so long as you have capacity, you're over 18 years of age, and it is executed with the proper will formalities, then at your death, the will is the document we look to settle your assets or settle your estate that are subject to it. And that is a topic for another time, but not all assets are subject to the will. It really depends on how your assets are titled and whether you have beneficiaries. I'm not going to delve too much into that in this episode. Look for that in future episodes, what assets are actually subject to the will. So a few important things to remember about a will is that it is only relevant when you die. And what I mean is you create it during your lifetime, but it has no legal effect until you die. That means that you can modify it at any time. As long as you have capacity, you can change your mind. When you decide who your beneficiaries are and what assets are going out to them, 5 years from now, that picture can be very different, and you definitely want to update your will to make it current. So it is a document that I always say This is true for all estate planning documents. I always say it's like tending a garden. If you don't tend to it, it's not going to flourish. It's not going to work very well. So a will is the same way. Okay, so that's a will. I'm going to go ahead and move on to a trust. Now, today I am really talking about a revocable trust. There are lots of types of trusts out there, and we'll have future episodes really identifying different types of trust. But for today, we are talking about the revocable trust. The revocable trust is very similar to your will. You identify how your assets are distributed at death and to whom. Now, what is different about a trust than a will is that it is relevant at death, but it's also relevant during your lifetime. When this trust is created, it's a living document at that time. That's because it is as if it's a separate entity or an extension of you. And let me just explain that by first talking about who the parties are to a trust. So the parties are the trustor, which is the trust creator. And in other jurisdictions, you might hear this referred to as settlor or grantor. But in Washington and Oregon, we say trustor. That's the person who creates the trust. Very similar to a will, the will creator is the testator, the trust creator is the trustor. So that's the person who is going to identify the terms of the trust, identify who the beneficiaries are under the trust, and to how they receive the assets at death. It also is the person who is going to identify how the trust assets are used during lifetime of the trustor. And that's because when a trust is created, it's effective at that point in time. It's not effective just at death. It's effective at that point in time. And that's because the trustor for a revocable trust is also the beneficiary of the trust. That's right. So you're creating this document where you're making yourself the beneficiary. I know that sounds kind of strange, but I think it'll make sense once we get further on in the episode. Now, you have the trustor of the trust, you have the beneficiary of the trust, and then you also name a person or entity to be in charge or manage the assets owned by the trust, and that's called the trustee. Now, when you have a revocable trust, the trustor, trustee, and beneficiary typically is all the same person. You can have different people be a trustee and, of course, a beneficiary, but when we're creating a revocable trust, one of the primary reasons people like to create the trust is to avoid probate. I'm not going to get too much into probate in this episode, but that is one of the primary reasons. So essentially, it's a vehicle where we take your assets, we put it in the trust, we name a trustee to be in charge of those assets for the trust beneficiary. If you are doing this with your own assets during your lifetime, you want to have control of your own assets typically. You want to benefit from your own assets typically. And you want the ability to be able to change the terms of the trust. And so that's why you, when you create this document, you wear all three hats. So a little bit further into the trusteeship of the trust document. So the trustee can change, and you as the trustor have the power to change the trustee. Now, why would you do that? Well, it's simple. During your lifetime, if you can't serve as trustee for any reason, typically it's because of incapacity, you want to be in charge and control of who monitors and protects the assets on your behalf and uses them on your behalf. So we appoint a successor trustee in that document. And you can think of a trustee, it's very similar to an executor of a will. However, the trustee can step into that role during the trustor, the trust creator's lifetime, and they can also step into it once the trustor dies. Okay, now I said the beneficiary of the trust is also the trustor, the trust creator. However, we are also going to name beneficiaries that inherit when the trustor dies. So that is the piece similar to the will, is that the trust lays out who will inherit and how once the trustor dies. Now, that is one of the major differences between a will and a trust in terms of when it's effective. Will doesn't really matter what it says until death. Doesn't go into effect until death. A trust goes into effect as soon as the trustor signs the document. Now, I probably had a few words regarding the trust that are unknown. And so I'm going to kind of step back and break down the trust a little bit further. Earlier, I said that a trust, people like to make a trust to avoid probate. Probate is the process of settling probate assets when a person dies. And the primary vehicle for probate is the will. And that actually is a misconception for many. Many people think that if they have a will, they avoid probate. That is untrue. The will is the primary document that goes through the probate process. So just to break down probate quickly, and I'm not going to go too much into probates because we have future episodes where we break this down. However, probate is a court supervised administration to settle an estate at death. And in simplified terms, when a person dies, their will, if they have one, gets submitted to the probate court. The executor or personal representative, as we call it here in Oregon and Washington, asks the court to be appointed in that role. The court typically will say, fine, we will allow whoever is nominated under the will to settle the estate. We will allow them to go ahead and settle the estate. And the court gives this person special papers that gives them authority to do what they need to do to settle the estate, pay bills, and distribute the assets. Now, probate is a fairly lengthy process in Oregon, and I'll say in Oregon, it takes about a year. It used to take around 9 months to a year. Now it's extending to about a year. And unfortunately, depending on the jurisdiction where the person has passed away, some jurisdictions take a little bit longer. In Washington, it is about a similar timeline. However, I do think in Washington, we can open and close a probate a little bit quicker, but not much. It's probably more of that 9 month to a year timeline. So many people like to avoid that process. Now, just to make it easier on those they leave behind, a trust vehicle can pass out assets a little bit more quickly than a will vehicle through probate. And that's because a trust avoids probate. Now, how does a trust avoid probate? We actually title your assets in the name of the trust once it's created. And what I mean by that is, if you have a bank account, which most people do these days, and you go to the bank and you open an account, recall filling out paperwork and signing some documents, et cetera, et cetera. That is you in your individual name and capacity opening an account. You do the same thing with the trust, but instead of opening that bank account in your name, you're opening it in the name of the trust. So for example, if I have a revocable living trust and I have a bank account, I want the title of that account to be Tammi Caress, trustee of the Caress Revocable Trust, or whatever the name of my trust is. You still have all the same powers, rights to the account. You can still do everything that you normally could do if it's in your own name. It's just under the trustee or the trust name. So by that act of titling the account and the trust, the trust now owns it. And that is how at death, probate is avoided. Okay. So that's trust funding. I'm going to just give you one more example because it's very common. Your home is another example. When you buy a home, you buy it in your name. If you have a trust, you would buy it in the name of the trust. Again, you still have all the same rights, powers to that home that you would if you owned it under your individual name. You still pay your taxes on that home. Unfortunately, it doesn't avoid that. But that is, again, how we fund the trust. So that's called trust funding. Now, of course, when people come to me and we're creating a new revocable trust for them, they already have assets. So what do we do then? Essentially, we just retitle them. So for example, if you have a bank account, a lot of people have loved ones they might add onto the account. I advise against that typically, but that's a future episode. But let's just say you want to put your niece onto the account with you. A lot of people think, oh, this is just going to make it easier to add them. Well, think about it. You have to go to the bank. You have to sign some paperwork allowing your niece to be on the account with you. And probably your niece has to sign it as well. Sign some paperwork as well. And now the account is not owned by you individually, but you and your niece. Well, it's similar, same process with a trust. You have an account already in your name. You're going to go to the bank and you're just going to rename it so that your trust is the owner instead of you. Typically, you don't have to change accounts to do that. You don't have to open up new accounts to do that because when you have a revocable trust, your social security number is tied to the trust, and therefore the bank should not have any problem putting your trust name on the account as opposed to you as an individual. I will warn you, some banks do, they're a little bit more challenging to work with than others. A lot of times what I find is it's just the person that you're working with at the bank. And we just need to get a new person to help you. But nonetheless, that is how we avoid probate by use of a revocable trust. So just to do a little recap on will and trust, a will, you have the will maker, the testator. You have the person who is settling your probate estate under your will. That's the executor or personal representative. And then you name a beneficiary who will inherit from you at death. The will is only relevant once you die. It's only relevant with regard to probate assets. And I didn't really talk about this, but it really is just one piece of the estate planning puzzle. You have many different assets. And like I said before, they pass differently depending on how they're titled. Again, another episode. And then to recap the trust, it also is effective at death, but it is effective during your lifetime, unlike a will. The party is the trustor, the trust creator, the trustee, the person who oversees and protects the trust assets. And then, of course, you have the beneficiaries named in there. And then when the trust is created, typically the trustor, trustee, and beneficiary is all one person, the same person. The trustee can change, and that is when, and the trustor names a successor trustee, and the trustee changes when the successor trustee can no longer serve. That would be because of death, It would be because of incapacity, or it could be because the trustee decides they don't want to serve anymore. So you would name a successor trustee to carry on and manage and protect the assets for the trust beneficiaries. The trustor is the trust beneficiary during lifetime. And then we have remainder beneficiaries who are named in the document to inherit when the trustor dies. Okay, so I'm just going to get into a little bit of why choose a trust over a will. First, to avoid probate. I talked about that already, but the court supervised process to administer an estate, that's the primary, the will is the primary vehicle for probate. So I'm going to say it again because it's really important. A will does not avoid probate. It is the primary vehicle we use to go through probate. Okay. A trust can avoid probate so long as we fund it. Funding the trust, again, means your assets are owned by the trust, not by yourself. And we have to usually fill out some paperwork with the bank, record a new deed to your home, and then the trust is the owner. Other reasons why people like to have a trust: privacy. Now, with the will, when a probate, we're going through probate, anything in that probate is a matter of public record. So anyone, if they want a copy of your will to see who your beneficiaries are, they can get it because it's a matter of public record. Also, when you go through probate, the personal representative has to file an inventory of all the assets in the probate. We also have to publish notice in the local newspaper for any unknown creditors to make claims. And then there's also a final accounting that we do. And in that final accounting, we're telling the court and anyone who wants to know what you owned when you died, what happened to those assets since you died, what bills you had to pay at death, and then how much everyone receives. So going back to the trust and privacy, a trust does not have the public record tied to it. It is a private document. No one is going to know except those in your trust that you have named to receive assets from you. No one will know what you owned and what creditors or debts you had. So that's important to many people, is the privacy aspect. Some people don't care. But that is another reason why people like to have a trust over a will. The other is what I call problem heirs. Problem heirs are those people that you don't necessarily want to give anything to, or maybe you're disinheriting from your estate, or maybe they're getting a little bit less than someone else, and you're just very concerned about these heirs coming in and making a problem. So going back to the probate, a probate, when a person passes away and the beneficiaries under their will, those beneficiaries will all receive notice under their probate. Okay. Also, heirs will receive notice under a probate. Heirs are those who would have inherited from you if you didn't have a will. Okay. It's different. It could be the same people, but it also can be different. And what that means is if a person dies without a will and they have probate assets, we're still going through probate, but instead of looking to a will to see who is inheriting, we actually look to state law. So state law will dictate who inherits from you if you don't make a will specifying who inherits from you. Another very important reason to at least have a will, because then you have control who inherits from you. If you don't, you have no control who's going to receive your assets. So you may have an estranged family member. It could be a son or daughter. It could be a grandchild. If you don't have any children, it could even be a sibling. Siblings can inherit from you if you don't have a will disinheriting them. So sometimes they're estranged for a reason. It could be there's always at least one person in the family that can cause some problems, at least from my experience with many of my clients over the years. And if you're worried that they may cause a problem, if they are an heir under law, they will receive notice of the probate. And what that means is they will receive a copy of the will. They'll receive a notice that says they have 4 months to contest the will. That is required under the court, and it could open up a can of worms for those problem heirs. When you have a trust, the only people that get noticed of the trust are the beneficiaries, and they don't get notice until you die. So don't worry about that. It's still a very private document while you're alive, but at death, we have to notify the beneficiaries that they're a beneficiary of this document, but no one else is entitled to a copy of it. So that's really great. We can keep the lid on tight with those can of worms. So problem heirs is another reason. If I have clients that do have a family scenario where it could even be an in-law that they're concerned would cause some problems, a trust is a good vehicle for them because we don't have to give notice to those people. Okay. The other reason people like to have a trust is efficient distribution of your assets at death. That's simply because we're not going through probate. Probate, there is a defined timeline. That is because the court requires notice to beneficiaries and with opportunity to object to the will. The court also requires notice to potential creditors, and that's a 4-month period. We have to file notice in a local newspaper, wait 4 months to see if there's any creditors coming out into the woods. And the court also does not want any assets to be distributed out to the beneficiaries until it is satisfied that the personal representative / executor has done everything they're supposed to do, which includes filing tax returns. And that filing tax return piece is often the reason why the probates remain open and haven't closed, and now it's a year. And that's because we have to file taxes, and sometimes we can't until we have all of the tax information, which may not be until January of the following year of death. And so the court, at least in Oregon, is not going to allow disbursement of assets until it knows that all taxes have been filed and paid and all creditors have been notified and paid. So that's what can take a while. With a trust, we don't have to wait for those timelines. In fact, oftentimes what we want to do is there is a little bit of a waiting period typically because we want to gather the assets and get them appraised. And that's a benefit to the beneficiaries who are inheriting those assets. But it's also because typically there is an estate tax return that we have to file with this, which is a death tax. More about that in future episodes. But once we get that information and we have an idea of what the creditors are, we can actually make a disbursement and hold back enough funds to make sure we pay off the taxes and the creditors and things like that. So with a trust, we can get assets out more quickly. We can also make small disbursements if necessary. For an example, if you have a minor child that needs support with a court, it's locked up and we have to go and ask court permission to get the money or disperse an asset. And that's a big process with the court. Takes some time, costs extra money. More funds are needed to make that happen. With a trust, we could actually say, oh, your kid is in college and we need to pay their tuition, or we need to pay their utility bill, their car insurance, whatever it is. The trustee can do that, which is a really nice benefit to a trust. A probate, those kind of small disbursements are not going to happen without a court approval. And that's just, it takes a long time to get it, for one, and doesn't really offer the support that typically you want for those, younger loved ones you leave behind. The other is estate tax minimization. And I'm not going to get too much into this. You can, with a will and with a trust, do some tax planning for estate taxes. The difference is it works much better with a trust. And that's all I'm going to say about that for now. It just works a lot better with a trust. Why people choose a trust over a will is to avoid a conservatorship. Now, a conservatorship is another court process when a person doesn't have capacity to manage their own assets. And that could be because they truly don't have capacity as an adult, or it could be because they're a minor child. And if you have a trust, you can actually set things up for your younger adult child or niece, nephew, whoever it may be, and minor beneficiaries without having to have a conservatorship. So a conservatorship is, like I said, it's just a long court process to get someone named to manage the assets for someone who lacks capacity due to age or another reason. Also, a conservatorship is important for the trustor. If you have a trust, like I said, remember when I said it was a lifetime document? If you have a trust and your assets are owned by the trust and you become incapacitated, you have already named your trustee to manage the trust for the assets for you under a trust. Therefore, you don't have to go through, or someone doesn't have to go through a conservatorship for you. If you didn't have a trust, it's possible that a conservator, someone would have to, if you're incapacitated, someone would have to file or petition the court to be appointed as your conservator to oversee the assets for you. That is a very expensive process that can be easily avoided with a trust. Not only that, you as the trustor get to decide who that person is. You don't have no decision making if someone is petitioning the court for conservatorship. You don't have control over who that is and who gets appointed in that scenario. Also, it's super disruptive. If you're, just think about it. If you're incapacitated and someone is trying to be a conservator for you, the court requires that you receive notice, and it is personal notice. And what that means is a physical person has to come and hand you court papers, kind of like you're served. That's super disruptive. If you're incapacitated, can you imagine how that would feel? I mean, that would be, it's just not a good scenario. So a trust can avoid that. Okay, moving on. Like I said before, it's management of your assets. So you get to decide who manages the assets on your own behalf when you can't manage them yourself with a trust. That is very useful. Again, better for you to choose that person than have someone else choose for you. What I like about trusts as well is that it can protect the assets from a beneficiary's creditors, divorcing spouses, and even you can protect a beneficiary from themselves. And I'll delve more into this later, but essentially you have control, especially if you have, like I said, a minor beneficiary. If you have a beneficiary who isn't a minor, but maybe they're not good with money and you want to make sure the money doesn't get spent unwisely. Also, if you're, this is actually a big concern I hear from clients, their child's spouse. So if you want to make sure that child's spouse doesn't get anything, you can actually outline it in your trust. Okay. So those are the reasons why many people like a trust over a will. Now, it doesn't mean you have to have a trust. A trust isn't just for the mega wealthy. There's lots of reasons to go with a trust instead of a will, for the reasons that I just spelled out. But sometimes if none of those reasons you care about, maybe you just want to have a will, and that's okay. If you don't care if the beneficiaries need to wait a year to get the assets, that's fine. I personally think avoiding probate at all costs is a good idea, but it really is what's important to you. Okay, I think that's good for today. Hopefully this has been super helpful for you. I want to direct you to my website because I have lots of resources there. And also I have an estate planning primer, which is really kind of outlines the probate process and talks about a revocable trust. And then also check out my blog. I have a blog specifically defining the difference between wills and trusts that could also be helpful. And if you look in my show notes below, I'll have a link to that. Thanks so much. My website is caresslaw.estate, and that's CARESSLAW.ESTATE, no .com or .net. This is Tammi Caress. Thanks for listening.